Today, I'd like to share with you 6 ways that a poorly written trust can cost your family hundreds of thousands, if not millions of dollars in trust expenses, litigation expenses, IRS payments, and all sorts of other things that will ultimately cost your family frustration and a lot of time wasted. Recently, I had a client who had been a long-term family client for almost 20 years that saw their family ripped to shreds and stressed to no end based on an old, outdated trust, frankly drafted probably by an incompetent attorney. And we ended up, luckily, mediating all of the disputes with all of the parties, which was great. But it took us about 1.5 years to get to that mediation. And we had to file multiple petitions in court to try and get some solutions and some help in figuring out what to do with this poorly drafted trust. So first, the huge issue we had was a problem with allocation between 2 subtrusts. As many of you know, trusts are sometimes divided into 2 or 3 separate subtrusts at the death of the first spouse or even at the death of the second spouse. So in a situation where you have an allocation that's supposed to happen with assets dropping into 2 or 3 separate subtrusts, you need to have clarity in terms of which assets are supposed to go into each subtrust, or how much income is supposed to be generated, or some other indicators or formulas so that the lawyer who is helping the trustees administer the trust at death knows what to do. A lot of this was not done in this trust, and that meant that not only could the lawyer and the trustees not do the work they needed to do, but the CPA who needed to file the 706 return, which is the estate tax return, couldn't do that. As a result, while we were waiting for the court to opine on how to do this division, because the trust gave us 0 indication of what to do, we had to pay $17,000 a month of interest to the IRS during the entire pendency of this dispute, because the 706 return required allocation to be final. We do not have any sort of code section or forgiveness in a situation like that with the IRS when you have a poorly drafted trust. So it's just, you will pay for it and that's the end of it. The second problem is we had missing documents. So some of these older attorneys who maybe weren't digital, or maybe, had somebody pass away in their office, may not have all of the records. And since trusts are designed over time, as the client, you may also not have all of the paper records or digital copies. Well, in this particular instance, we didn't have one of the amendments to the trust. We generally knew that there was not much in the First or Second Amendment that was missing, but we still could not administer the trust because we needed to have clarity on what was said in there. Somebody could allege that they were given $1 million gift in that amendment. And until we have clarity, the trustees would be exposed if they just ignored it, because they could be sued for a breach of trust. So another problem we run into with poorly drafted trusts is that sometimes the trust desires to provide a certain income or asset or lifestyle to an individual, but they didn't take into account what the current assets of the trust allow. So you could have a shortfall of asset, you could have assets that are plentiful, but they're not liquid enough to provide an income, or you could have some requirement that taxes or other liabilities be paid with the income such that the beneficiary can't receive the money. So maybe it worked at one time, but again, the older a trust is, the more likely it is that your assets and your income have changed, and the trust needs to be updated from time to time. Now, this is not necessarily the problem in the 4 corners of the trust document, but another common problem I really run into in trying to administer trust is finding out that the decedent, the person who is the grantor in the trust, passed away without using all of their lifetime exemption amount for gift tax, which is the same exemption amount as the estate tax. So in a particular administration that we just dealt with, she had remaining $12 million of exemption that she could have used to move assets out of her estate. And what that would have allowed to do is all of the appreciation and the income coming from that would have been entirely separated out. So unfortunately, we had to pay estate tax, which is a 40% tax, because she hadn't really maximized what is such a simple thing to maximize, which is your lifetime gift exclusion. Last but not least, we had litigation with the spouse of the decedent. So like many high net worth individuals, when they come together later in life, or even if they come together early on in life, their family assets or their independent wealth is retained in a separate property trust. And a lot of times, in order to get the exemption of the spouse who may not have as many assets, they will have a marital trust provision or even a bypass trust provision that provides for the spouse. But it's not necessarily going to go well unless you've really parsed out how that spouse is to be cared for, because you want to utilize that exemption, of course. But what you don't want to do is invite them to the table to have a voting share or to have some right to poke around in the accounting and the financials of a family business. A lot of times these separate property assets, especially when they're family businesses, they operate really with the family as the management and then maybe the spouse as the beneficial interest holder or the beneficiary of all of that money coming to the marital estate. But what they don't want to have is a spouse having voting right or a spouse just being able to ask for things, which slows down the business and frankly sometimes feels like a breach of privacy or a breach of trust. So a lot of times, again, a trust needs to account for what kind of rights the spouse has and whether that right continues to and spills over into asset management for family business assets. A lot of families may want to consider having a special voting trustee, a proxy so that someone in the family is voting those shares, a buy-sell agreement that triggers a buyout of the spouse's interest if they inherit, all sorts of things that need to be looked at when you're talking about a family business in particular. And then we do have to consider whether we want the last item that I see often in a situation where we have one decedent leaving a spouse behind, or maybe even a special needs child or a young child behind. They've provided for some sort of a life estate, maybe in a family home, or some sort of lifetime right to access or use that home, or maybe even it's a vacation house or a cabin that's been in the family a long time. And in a situation like that, the trust document really has to be clear, is what is included in that lifetime right or lifetime access to that real property. And a lot of times what I see is it'll say rent-free, but it won't say who's maintaining the home. It doesn't account for whether there's going to be continuing income to the trust to provide for maintenance of the home or property tax payments or anything else. Sometimes the trusts do not even account for what really needs to be done if they want to sell and downsize, right? If they want to have a home, but they don't necessarily need a 5,000 square foot home as somebody who's aging and can't get up the stairs. So a lot of times that specific issue needs to be looked at. It's very gracious to make sure that your spouse does not have to leave, even if it's not technically their property. But we don't want to breed distrust or a conflict between the next generation or other beneficiaries and a spouse, because a lot of times it does happen if it's not clearly addressed in the document. So unfortunately, in the case of the family we just got through a mediation, the dispute lasted almost a year and a half, and the mediation was really a saving grace, but everybody had to agree to come to the table, and we didn't necessarily have that as a guarantee. If they wouldn't have been able to mediate, it would have been an additional year and a half until we got to a time where we could try these issues, because they were in dispute between the family and the spouse. So it was a really difficult situation, a very expensive problem to solve, not just the cost of litigation, which is always astronomical in the state of California these days, but we also had this accruing liability to the IRS, interest that was owed, and a lot of other penalties and things that accrued along the way because we couldn't meet any of the IRS deadlines until these issues were resolved. So hopefully you've learned it's time to crack open that trust binder, take a look at what your document says, and maybe put some Post-it notes in there or look to see if it really is a reflection of what you want first and foremost, whether it's something that's clear to a third-party reader, and whether it's something that needs to be updated for the law. So please take a look at those documents. Please go get them updated updated. Please make sure your estate planning attorney is still alive and in practice or has a good succession in place, because all of these things will help your family at a time of either death or disability, so that there's a smooth transition and there's not a lot of time and money that's getting wasted in trying to cobble together, really was your vision to make sure it was realized. Thanks so much.